If you've ever thought about taking the driving penalty points for your spouse or any other person, then I'm here to warn you that that might land you in prison. And I'm going to explain why in this video. You see, many people might think it's relatively harmless to say that they were driving instead of their spouse, and this typically comes about when they have 9 penalty points and another 3 would take them up to 12, meaning a court appearance and a likely ban unless they can show exceptional hardship. You see, lying about who was driving and therefore taking the penalty points for someone else is not as harmless as it seems, because this actually amounts to a completely separate offence, which is indictable only, known as perverting the course of justice. Indictable only offences can only be heard in the Crown Court, and perverting the course of justice carries a maximum of life imprisonment. Although it's not likely to apply in cases like this, there is certainly a very real prospect of a custodial sentence if you are found guilty of perverting the course of justice, even if this did just arise out of saying it was you that was driving when in fact it wasn't. And if you need a reminder of how it works when the police send out a notice of intended prosecution and a 172 notice which requires the keeper of the vehicle to identify who was driving the vehicle at a given time and place, I'm going to refer to a video I made earlier. Now, as you can imagine, there are thousands of people every single day that are caught speeding either by the fixed camera at the side of the road or by a police officer, either by standing with a radar gun or in a van. And when this happens, there's a whole process that's set off in the background, and most of this is automated. And within 14 days of being caught, you should receive through the post a notice of intended prosecution. The notice of intended prosecution should come out automatically to the address that the car is registered to. That's why it's very important to make sure that that address is kept up to date, otherwise you may not receive it. Along with the NIP, which it's known in short, should also be a Section 172 notice requiring you to provide details of who was driving the car. The reason for this is that the cameras will ordinarily not capture a good enough photograph to show who was driving. And even if the photograph does indicate who was driving, you may still receive a Section 172 notice requiring you and putting you under a duty to provide details of who was driving the vehicle at that time. They're allowed to require this information from you if you are alleged to be guilty of an offence, such as speeding. Now, Mr. Swift should take this letter very seriously, because failing to respond to this letter is in itself a separate criminal offence, which could carry more points than his original speeding did in the first place. So he could get 6 points and a fine for failing to respond to this letter. Now, Mr. Swift is a bit concerned because he's not entirely sure whether it was him or his wife that was driving the vehicle at the time, because they do share the vehicle from time to time. But in response to the Section 172 notice, Mr. Swift could nominate his wife or any other person that was driving the vehicle at the time. If Mr. Swift wasn't sure who was driving at the time, he's expected to exercise reasonable diligence to find out who it was. That's under subsection 4 of Section 172. So what this means in practice is Mr. Swift should go back through his diary, find out what he was doing on that day, where he was on that day, where his wife was on that day if she sometimes uses the vehicle, and this is a duty upon him to exercise that reasonable diligence to find out who it was. Now, I must stress that it wouldn't be good enough for Mr. Swift to respond to say, I just don't know who it was, thinking that he'll get away with it, without showing that he's done this reasonable diligence and still couldn't find out. In other words, if the response is, well, I genuinely don't know who was driving, Mr. Swift will be expected to show that he's done some reasonable diligence and he just cannot find out which of them that it was. I must also flag up a severe warning here, because in some cases, some people ask their spouse or some other person to take the blame for this speeding, perhaps because they've reached 9 points, and if they roll over to 12, they might have a totting up ban, meaning that they will be banned for a period of time. I'll discuss this in another video. But in this case, if this person is asking someone else to effectively take the blame and take any points that come with the speeding, this is perverting the course of justice, and the person doing so, or both people doing so, may well be prosecuted for perverting the course of justice. So now back to the offence of perverting the course of justice, let's take a closer look at it and explore what it means. For those that are interested in common law, perverting the course of justice, like many other offences, is a common law offence, rather than a statutory offence. And the case setting this out was in 1891, and it requires a positive act. The offence is defined as being when a person acts or embarks on a course of conduct that has a tendency and is intended to pervert the course of justice. Looking at what the course of justice actually means, this was refined in 1982. And it's been held that a course of justice must be something that is embarked on, or in the proceedings, in progress, imminent, or under investigation that could result in some course of justice. As for the meaning of a tendency to pervert the course of justice, this means that there must be a positive act rather than an omission, even if the omission itself might be an offence by itself. But the positive act must be enough to have a tendency to pervert the course of justice. In other words, the person must have done just enough to risk an injustice without any further or subsequent action taken by him. Other examples of perverting the course of justice include making false allegations, concealing evidence, obstructing the police, and in this case, providing false information as to who was driving the vehicle so that the points will be applied to the wrong person. And as I said, whilst the maximum punishment for perverting the course of justice is life imprisonment, you can expect a typical sentence for this kind of case of between 6 and 18 months. Some of you might remember from 2013 that the former Energy Secretary Chris Huhne and his ex-wife Vicky Price were both sentenced to 8 months imprisonment for exactly this offence. In her defence, Miss Price said that Mr. Huhne had coerced her into taking the points, but the jury rejected the argument. So in modern times of increasingly sophisticated speed trap cameras, many of which will take a photograph of the driver, if it's clear on investigation that the person has lied about who was in fact driving at the time, you may well be looking at charges for perverting the course of justice, which, as I said, is an indictable only offence, which means you will find yourself in the Crown Court if you are indeed charged. And indeed, in the Attorney General's reference, number 17 of 2008, it was stated that it was only in the most exceptional circumstances that a person convicted of perverting the course of justice would not receive an immediate sentence of imprisonment. So I would firmly urge everybody watching this video to not even be the slightest bit tempted to take points for someone else or lie about who was driving. Because if the truth is discovered, then 3 points on your licence and a short ban are going to be far less things to worry about than facing Crown Court trial. So I hope that serves as an adequate warning. Please give this video a thumbs up if you like my channel, and remember, stay humble and subscribe.